Hello and good afternoon, Stuart. How you doing?
I'm doing good. How are you?
I'm doing well. Producer Eric?
I'm doing great.
All
Thanks for
right.
asking.
Always nice to hear your voice.
Thanks.
And everybody always compliments your voice. You really have a striking voice that everybody really loves.
Yeah, I've heard it since I was a young age, and I think everyone has. I'm serious, and people always say it's like weird to hear your own voice, and it kind of was, but I'm over it now.
Oh, okay.
Yeah.
Well,
But thank you.
We all enjoy it. So here we are doing back-to-back videos, which we don't normally do, or we haven't done in a while. But I guess it's because something interesting happened, and we want to talk about it. But what was that thing that was interesting?
I don't know. I thought you were going to introduce the issue today, so
Okay.
I'm waiting for you to introduce it.
All right. Well, so
I'm just here to wax eloquent whenever you introduce something.
okay. So let me lay this out for you, Stuart, so that you can then say all the smart stuff. So yesterday, was it yesterday? I think it was yesterday.
You're asking me for clarification again, which
Eric,
is
was
It was
it
yesterday.
huge
It was
mistake.
yesterday. Yeah.
All right. So we were on yesterday and trying to get my day straight here. And we were talking about a motion that was filed by Baldoni. So Baldoni filed a motion to compel, asking the court to compel Lively to produce medical records and her mental health records in support of or in furtherance of discovering her claim about emotional distress. And
Intentional infliction of emotional distress and negligent infliction of emotional distress, 2 claims.
yeah, so there's 2 different claims for emotional distress out of her many claims. I mean, I don't even remember how many causes of action, but that was 2 of the many causes of action
Correct.
that she filed. And so in response, the Lively side said, hey, don't worry about us producing them. We're just going to withdraw those claims.
Right.
And I think you made the point yesterday, Stuart, that that's not that abnormal in litigation. You'll see people withdraw claims. You'll see people withdraw affirmative defenses. It's kind of par for the course, as they say.
Yeah.
Would you agree with that?
Nothing too exciting going on here.
Okay. So now today, and then Lively filed a counterpunch. So she filed and said that the motion that Baldoni filed really was not necessary. It was just done to play to the media. And the only reason he filed it was to try and get this story out, because there was no need for him to file to move to compel, because Lively's side had already agreed to withdraw those 2 causes of action.
Correct. They agreed to withdraw them without prejudice. And Baldoni's crew said, no, that's not good enough. It's got to be with prejudice.
Okay.
And so they brought this squabble before the judge.
Right.
And what did the judge have to say about it?
So the judge did what a lot of judges do, which is, look, guys, just figure it out. Judges view attorneys going back and forth, especially on discovery motions. They view it as 2 kids in a sandbox fighting over a toy. And it's kind of like that frustrated parent where they're like, you're both grounded. And so he kind of dismissed everything and said, look, just figure this out. So do you want to go over the actual, what the order was?
I actually didn't pull it up. I'm sorry.
Oh, okay.
Do you have it?
I do. Let's see if I can share. I didn't put it in our other software, but this will still work.
It's just a short paragraph. I think he gave some guidance in his last sentence too, kind of where he's at on the whole issue.
Yeah. So sorry, guys. Give me just a second here.
There's a lot of people excited that it seems like this was a good time today. It just, matter of fact, worked out with a lot of people's schedules. So a lot of people are psyched to be here.
Excellent.
Oh, that's awesome.
And left Candace's live stream
to
hop on our channel. And a lot of people are like, yeah, same, me too.
Great.
Yeah.
So here it is. So this, made it too big. All right. So essentially, here's Judge Liman's signature. So he stamps this on the motion that was filed, or the letter motion that was filed by Lively's team. And he says that the motion to compel that Baldoni filed, and you'll notice it's dockets number 261, 262. He's denying Baldoni's motion based on the plaintiff's, meaning Lively's representation, that the relevant claims will be withdrawn. So because Lively has represented to the court, she's going to withdraw those 2 claims. The judge is going to deny Baldoni's motion to compel. And then Lively's request that, and he quotes, because the parties have agreed to dismiss Miss Lively's 10th and 11th causes of action. Well, there you go. There was 10 and 11 causes of action. The court exercised its inherent authority and authority under Rule 15 to dismiss them without prejudice is denied as well. So the judge is like, I'm not going to grant Baldoni's motion. I'm not going to grant Lively's motion. He does deny her what she's requesting without prejudice. So if she wants to bring some formal motion, she can. But for right now, he's saying, look, both parties are denied. And he's saying, look, the parties shall stipulate to whether the dismissal is with or without prejudice, or Lively shall renew her request by formal motion. So in other words, look, guys, figure it out. Meet and confer, do it with prejudice, do it without prejudice. Judge is saying, I don't really care what you do. Just get it out of here.
And if you can't stipulate.
And then, this was interesting. So for avoidance of doubt, if the claims are not dismissed, the court will preclude Lively from offering any evidence of emotional distress. Why would a judge do that if the claims are not dismissed? So if they're not dismissed, the judge is not going to take evidence?
Well, it's because Lively has said, I'm not bringing those claims forward. And the judge says, great, there's 2 claims that are gone. So those are 2 less issues to confuse the jury with, to confuse the lawyers and the judge with as we're moving forward here. And this is a pretty weighty case with a lot of moving parts. So if you can reduce the parts, kind of like Elon Musk, you're reducing the parts that are required to make a car, and then you reduce the amount of parts that are actually in a car, and you simplify the process. So you're just simplifying this case, which again is something that happens all the time in litigated matters.
And it also kind of shows you too that if you're going to go to the court and make a representation such as, hey, judge, you don't need to grant this motion to compel because we're withdrawing these 2 claims.
Right.
You better mean it, because
Yes.
The judge is going to make sure you stick to that.
Right. And I will tell you that Blake Lively does not want to have these 2 claims before the court. The question is why, and there's been lots of people guessing at to why she doesn't want these. But I feel very strongly the reason that she doesn't want these claims before the court is because she doesn't want her mental health records gone through. She also doesn't want to have to sit for an independent medical exam where Baldoni's lawyers will hire a psychiatrist to actually sit down and try to, find that there is nothing wrong with Blake Lively. So you have to go through that process, which there's some indignity in that. And then, of course, at the time of trial, she doesn't want all this stuff published for the world to read about. And so I think this is just a strategic decision to say, you know what, these claims really are not all that valuable in any event. And we filed, 25,000 claims to begin with because we wanted to make sure we didn't miss any. So we're going to withdraw these 2 particular claims because they simplify the case for us. They make it so our client doesn't have to sit. The fly in the ointment here was that Lively's attorneys were saying, hey, we're only going to dismiss without prejudice, meaning that they have the right to refile those claims within the statute of limitations time period. What Baldoni's crew wanted was they wanted to get the medical records so that they could give Lively a tough time. You're getting into her mental health records. I mean, what could be more invasive than that?
Very uncomfortable.
So they wanted to do that. And then they said, well, if you're not going to do that, then you have to dismiss this with prejudice. So the argument came down to, was it a dismissal with or without prejudice? And I think the judge made the right call here to say, hey, guys, you figure it out, get together, try to work it out with one another. And if you can't, then Lively can file a formal motion. But let me tell you this, since you've already told me you're not going to be bringing these claims forward, there's going to be no evidence on this going forward.
So he's saying as far as his case is concerned, that's before him, he's not going to take any evidence. But
Right.
if Lively were to dismiss without prejudice, she could still refile that claim at some point in the future.
She could, but she won't, because then you open yourself back up to having to turn over your medical records, which are also your psychiatric records, if she has any. Most of us have some psychiatric records. I know you have a plethora of psychiatric records, but
not as many as you think.
Well, most of us don't have as many as you do. But anyway, you wouldn't want people thumbing through that.
No.
And especially you wouldn't want people at a deposition asking you, why is it that you like to kill a cat when you were 8 years old? That's not a fun thing to remember.
I think you're thinking of Jeffrey Dahmer. That wasn't me.
Okay. All right.
Yeah. But like I said yesterday, I have no problem disclosing your medical records.
Yeah, I know you don't.
But yeah, I have a problem with mine.
Yeah.
And also somebody, I think from yesterday's video, made a point in the comments about wouldn't the statute of limitation kind of take care of this? So even if you dismiss without prejudice,
Mm-hmm.
what does the statute of limitation do?
I don't know. I think California, it's going to be a 2-year statute. I think it could be a 3-year, but for personal injury, it's a 2-year statute. I'm pretty sure intentional infliction of emotional distress and negligent infliction of emotional distress are both tort claims and going to be subject to personal injury. So it's going to be a 2-year statute, and it's a 2-year statute from when those claims arose. or when a reasonable person believed that those claims arose. We're getting pretty close to that 2 years. So really, this is more of an argument of, I want to be right and I want you to be wrong. So I'm going to make it as hard on you as I can. And so Lively's team is trying to make it sound like, oh, we're going to do this without prejudice, because that gives us the right to refile if we want to. And of course, they're not going to. And then Baldoni's crew is saying, no, if you're going to dismiss. And I think the judge actually did fall down on Baldoni's side ultimately on this, because he says, look, you've represented to us, the court, that you're going to dismiss this. So there's going to be no evidence on this. It's not fair to Baldoni's team to preclude them from looking into your medical records if you're saying, I'm not going to do this. And then, 2 months later, you come back to the court and say, oh, I've decided I want to put the claims back in.
Right.
You're going to have to wrestle with the judge over that.
Yeah, it'd be different if Lively didn't represent to the court that you don't need to grant this motion because we're dismissing those 2 claims.
That's
That'd
right.
be a different ballgame.
The thing that hits me about these 2 claims, though, is, and Keith, I would say to the jury pool, and this is just an opinion on my part, it's just a suggestion. I could be 100% wrong, but everyone's watching the content creators out there. And by the way, I love the content creators. I think it's causing a flattening of the media. I think CNN and Fox and MSNBC, they're juggling their lineups. They can't get people to watch their evening shows. I think people are watching YouTube and they're watching content creators because you're getting, we're not professional journalists by any means, but we're doing the best we can. And many of us are experts in what we do. Not everybody, but most of us are. But if you're in the jury pool and you're watching, Ask Two Lawyers, and I won't mention other content creators, and you find that those content creators are consistently on one side and not the other, like never, they're never on, they never say a nice thing about the other side. And they continually show outrage to every single issue that comes up in a case. And for example, when Blake Lively withdraws the intentional infliction of emotional distress and the negligent infliction of emotional distress, I yawned, because it's like, yeah, that's how this works. And I understand why she's doing it, because she doesn't want her medical records brought into this. But it's not that big of a deal. But let me give you a couple of the headlines that I read today and yesterday. Blake Lively humiliated in court. Okay. Blake Lively withdraws part of her lawsuit, ! Blake Lively just suffered a stinging loss in court today. This is devastating to Blake Lively's legal battle. Breaking, Blake Lively admits defeat. And then we have, and I will call out one content creator, we have the Daily Dose of Donna, where she is actually reasonable in her headline. Blake Lively withdraws claims for emotional damage. And that's exactly what happened. So thank you. I didn't watch Daily Dose of Donna's view of this, but the headline is not outrageous. It's not, it reminded me of my mom used to tell me, when a little boy calls wolf, too many times, at some point, it's not important anymore, and people kind of lose interest in what's being talked about. And so I wrote down a couple things here. And in my mind, again, for the jury pool here, when you're watching people, you should think critically. There's times when Ask Two Lawyers is going to be wrong about things. That doesn't mean they're bad people. Doesn't mean they're unethical people. I would say that the people that wrote these, in my mind, bombastic, as you like to say, headlines, I don't think these are bad people. I think they're trying to capture attention. I think they want to talk about something that they like, and they may be 100% on Justin Baldoni's side. They may be 100% on Blake Lively's side. The point is, if somebody's always on the other side and they have nothing good to say about the other side and everything's bombastic and every issue that comes up in the case is something that's just unbelievably important, then my thesis is that nothing in the case is important after that. Because if there's 100 issues in a case and you're continually telling people how important each one of those are, at some point people get fatigued. At some point, judges and juries and just the general public, they don't want to hear it anymore because you've been so bombastic on every single thing that happens. And of course, you're only doing it on one side. It's like the echo chamber just won't stop. And so you're risking your credibility. You risk your credibility if you make every issue a big deal. Like when Blake Lively withdrew these 2 causes of action. She's withdrawing half of her lawsuit. No, it's 2 causes of action, and it happens all the time. She suffered a great embarrassment today. No, it's not a great embarrassment. It's something that happens daily in court. How about saving it for a 12B6 motion either being granted in Blake Lively's favor or in Justin Baldoni's favor? That's a big news day. And that is something that's worthy of our attention and looking at and delving into. But 2 simple causes of action out of 12 or whatever it is at the end of the day, it's really not that big of a deal. So do you agree with my analysis thus far, or do you disagree with it?
I mean, I agree. So I think there's a difference of view when you're an attorney versus a layperson. So being that we're attorneys, we do litigation. It's not uncommon throughout the course of a litigation for claims to be dropped, affirmative defenses to be dropped. When you first have to plead your lawsuit, you have to state all possible causes of action. As a lawyer, that's a lot of stress. And so what you're going to do is you're going to state everything you can think of, and you're probably going to overstate a few claims, or you're going to stretch it a little bit, because that's your obligation. You have to state all causes of action that are applicable to you. So you don't want to miss anything. You don't want to mess up. And so you throw the kitchen sink at it. But I could see, though, if you're not a lawyer and you're not used to this sort of thing, when you hear that there's 2 claims that Lively's withdrawing and they have to do with emotional distress, which seems to be the kind of cornerstone of her case when you're thinking about, sexual harassment claims and things, it deals with a lot of, emotional distress, you would think. I would think that just from that point of view, you would think, wow, that sounds like a big deal. That sounds like she's giving up on a very important part of her case. But if you look at the remaining causes of action and those 2 causes of action in particular, they were lower down on the list. And that's probably why they were cause of action 10 and 11. They were not one of the high up causes of action that she really needs to hang her hat on. So, but I get your point. I mean, your point is if you start saying everything is important, then nothing's important. So what really is important on this case when it comes to Blake Lively? So I think there's a little bit of a difference there. The other thing I would say too is I think we've talked about this in prior videos. We did a video about how to argue and things. Charlie Munger was a very big proponent of be able to articulate the other side's argument. If you can articulate the other side's argument, then you will completely understand your own argument.
Right.
And I think that's another point is that, when you only shield yourself and you only want to hear your side of the story and your arguments, you're going to be weak on your arguments because there's going to be some counterpoint out there that you're not considering. And we do that all the time in our practice. You and I will argue a point back and forth, and we'll take different sides of it just to probe it and see, have we built up the best argument that we can build?
Well, not only do we do that, where I'll come to you and say, I have this great idea, and I tell it to you, and then you tell me all the reasons why I'm an idiot. And many times it ends up we discard that argument. But I don't
typically say idiot.
But every once in a while we have a good argument that comes from it.
Right.
The other thing is when we stand in front of a judge or a jury, we can't feign outrage. And we can't be outraged about 20 things in a trial. You just can't. And I'm sorry, I wish you could, but you dilute your strong claims. And if everything matters, then nothing else matters. I think that's important to take that in. If everything matters, nothing else matters. And clients have a tough time with this too, but you've got to pick your best arguments. And there's plenty of good arguments for Justin Baldoni here. There's even, I dare say, good arguments for Blake Lively. We'd like to hear more of them, but there are some good arguments. She's got some good lawyers on her side. And to think that this is going to be a cakewalk for either side is I don't agree with it at all. I think that if they go to trial, it's a 50-50 shot. It really depends on what jury you draw. And believe me, there's going to be jury consultants, although jury consultants they're only right, what, how many percent of the time?
50.
50% of the time. So
am I.
So we're pretty good at picking juries ourselves. Sure. Yeah,
and what about the damages? I mean, sexual harassment still comes with a substantial amount of potential damages if it were proven. But if it goes before a jury and a jury decides to side, with Lively, which obviously based on the evidence that we've seen on those claims, it's hard to imagine that could happen. But let's take it out of this context. Just on your general sexual harassment case, it's ultimately up to the jury to decide damages, right?
Yes,
and
correct.
So couldn't they decide the amount of damages that they want to decide without these 2 claims?
Yeah, it's up to the jury. If there's a damage component in the jury instructions, it's completely up to the jury. And you'll see defense lawyers and plaintiffs lawyers, there's a lot of fight that happens in voir dire. Voir dire is when we get to talk to the jurors and introduce ourselves. Well, what plaintiffs and defendants are constantly doing is trying to set expectations about damages. And it used to be that trial lawyers would spend all their time talking about liability. Who was wrong? I'm going to prove who was wrong here, rather than what's the impact and what are the damages that come from that liability. And really good plaintiff lawyers, and we know a lot of them, over the last 20 years, they've really shifted to spending, sometimes up to 70% of their time just talking to the jury about damages. And that's important. So when a plaintiff lawyer talks to the talks to the jury here, when Blake Lively's attorneys, and they're going to be good lawyers. It may not be Ezra Hudson that is doing the opening statements and voir dire and all that. But when they talk to the jury, they're going to be talking about, hey, is there anybody here that's uncomfortable with giving less than $1 million? Like they would never give more than $1 million for a sexual harassment claim. Could you please raise your hand if you believe that no matter how much evidence I show you, you wouldn't give more than $1 million? Well, you're asking that question to talk to send a signal to the jury, this case is worth millions of dollars because I'm asking you. And if Mr. Smith raises his hand and goes, I don't care how much evidence you give me, I could never give you more than $1 million, you're going to be able to excuse that juror for cause, right?
Yeah.
I mean, after you really get them to double down and triple down and quadruple down that they would never give more than $1 million. So damages is really where it's at in this case. And whether you get those damages through intentional infliction of emotional distress or negligent infliction of emotional distress or sexual harassment or whatever the claim is you're making from a tort standpoint, you can get significant damages from a jury if they determine that damages are due to you. So this did not take away Blake Lively's ability to seek damages against Justin Baldoni and the other defendants in that case.
Yeah, I think that's the key takeaway here, because I have heard some people that this takes away a huge component of her damages. I don't think it does. It takes away 2 of her causes of action. And again, they were kind of lower down on the list. They weren't the more important causes of action. Now, I will say that the letter motion that Baldoni filed, where he asked the court to compel her to produce the records, it kind of seems like it had a reasonable result, which is, look, we're filing this because she says she's going to dismiss these claims. She hasn't. We're arguing over whether it should be with or without prejudice. So, Judge, look, we want you to enforce our right to get her medical records. So, I mean, number one, it put pressure on Lively's team. But number two, I could see where you would be frustrated if you're like, look, we're entitled to the records. You're saying you're going to dismiss these things. You're not. So we're just going to go in on our motion and ask for that. I think Lively's response to that, though, where she's like, oh, they just filed that just to get the media. I don't know. It didn't ring very true to me. I mean, I kind of felt like Baldoni was filing for a purpose. Now, maybe he filed too quickly, or maybe he should have waited and they could have worked it out. I don't know. But he got a good result from it because the judge is like, hey, parties, you work this out, but whatever happens, I'm not bringing in any evidence, at least as to those 2 claims.
Yeah, it could be, Keith. I think that both parties here are well aware of the public perception and the public interest in this case. And I imagine that influences many of their decision-making, even decisions that are court-related. That's got to be in the back of your mind. How is the public going to view this? So I think that's there. I thought of one other thing. Many times defense lawyers will withdraw or basically concede to liability when they go into a trial. So you'll fight for 3 to 5 years over discovery and motions to dismiss, demurs, we call them in state court, motions for summary judgment. There's this big, long fight for 4 or 5 years, and you get right to the point where you're about to pick the jury and you're back in the chambers conference with the judge, and the defense for the first time says, oh, by the way, we're conceding on liability. We're not going to contest liability. Why does a lawyer do that? Why does a defense lawyer say, we don't want to make liability an issue in this case?
Because it takes away a lot of evidence. So then it limits the evidence you can bring in, because then you can only bring in evidence as to damages,
Correct.
Not liability. And all of that liability evidence
is damaging.
Yeah. And it actually does affect damages. And so when you have a case where liability, you don't think you're going to win on liability anyway, they'll do that at the last minute. They'll admit to liability to shrink the amount of evidence.
I like the word. Let's go with it. So I think there's some content creators that are out there right now. Again, everyone has a right to do their content creation however they want to, and I think it's driving conversation. So I'm not against anybody saying this stuff, but if somebody were to see a defense lawyer, give up half of their case by saying, I hereby concede on liability. In other words, I'm going to keep the jury from hearing all of the nasty evidence on liability because I don't want them to get excited and give a lot of damages. So I'm going to handcuff the plaintiff's lawyer to have to only talk about damages. And then the jury's left confused because it's like, well, why am I giving millions of dollars? I haven't heard anything that really excites me. But if some of the content creators had heard that, they would have said, oh my word, this defense lawyer just got humiliated in court and gave up on liability. And it's like, that's not what's happening. In my opinion, that's not what's happening.
Well, I think that's a disconnect between being, having experience as a litigation lawyer as you do versus being a lay person where this sounds a lot more bombastic, I'll say it, because you don't really understand the ins and outs of how this works. The other thing
Excuse me, sir. I've been told that I'm only an estate planning lawyer, so I don't know anything about litigation.
Well, you're in court a lot, I'll tell you that. The other thing that brings to mind too is that anytime, and we've been in a position too where sometimes we dismiss claims, and anytime you're dismissing a claim on behalf of a client, you almost always want to do it if you can without prejudice.
Yeah.
Just as a safety valve.
Sure.
You don't plan on refiling it, but there's something inherent in attorneys where we're super conservative.
Right.
And we don't want to dismiss something with prejudice unless we absolutely have to. Now, the times when you have to dismiss with prejudice typically is when you have a settlement agreement. So
Correct.
Everybody has settled and you've agreed that you will dismiss your action with prejudice.
Right.
And even then it's a little like, okay, I mean, we have to, but it doesn't feel comfortable. Whereas when you're on the other side, when you're on the Baldoni side, of course, and the other side's dismissing, you always want it with prejudice because you want to shut that door. So some of this argument back and forth is because the attorneys on one side want to keep the door open just to make themselves feel comfortable, and the other side wants to shut it to make themselves feel comfortable. And that happens in every situation that I can think of between lawyers on different sides.
And the pressure is immense for both sides.
A huge pressure for both sides. Yeah. And it's always on your mind. I mean, that pressure that you owe to the client, what if 6 months from now, the client's like, why did you dismiss that? I want to refile it.
Right.
I mean, who knows what?
Yep.
So there's a lot going on there that kind of behind the scenes that we don't even know about.
That's true. So to bring this all together for me, when I look at the content creators out there, which everybody keep doing it, it's good stuff. It's getting discussion started. But the jury pool, from a critical thinking standpoint, who are the content creators that sometimes are calling balls and strikes for Lively in a positive fashion, or calling positive fashion for Justin Baldoni? Are there times where you feel like the person is being more objective, perhaps, than other content creators? Well, still use your critical thinking skills with everybody. But if you just hear somebody that's just beating the same drum over and over again, and everything is an outrageous thing that Blake Lively did or that Justin Baldoni did, in this case, it's mostly what Blake Lively did, just realize you have to save your fireworks. You have to save your fireworks for the appropriate time. There is a time to shoot your fireworks off. There's a time to attack. There's a time to retreat. There's a time to love. There's a time to die. There's all these times, right?
You should write a song about that.
But it shouldn't just be full force. Everything that Blake Lively does is evil and horrible and unethical, and everything her lawyers do is also evil, horrible, and unethical. It's okay to point out things like we did yesterday, where we say, why the heck did they not disclose that Ezra Hudson was on the board of one of the amicus brief writers? I mean, it seems to me a no-brainer that you would disclose that. And you and I both were like, that
destroys neutrality.
That's crazy. Yeah. These are supposed to be independent amicus briefs, and you've got one of the party's lawyers that's a board member. I mean, that to me was something to talk about and go, oh my word, I can't believe that that was missed. What an oversight! What an embarrassment! Those are things that I feel as a lawyer, hey, we should talk about those things.
Yeah.
But whether there's a little jockeying going on here with withdrawing claims out of 12 claims that are made, because really the intent is, I don't want my medical records disclosed. I'm pretty sure that's what the issue is.
Yeah.
Which would be my thing. I would tell my lawyers, no, you're not disclosing my medical records.
Yeah, that's true. Yeah. And I remember I was watching, I think, Zach Peter this morning, and he was talking about how it's interesting how one of Lively's arguments about the protective order was she wanted the attorney's eyes only because of her medical records.
Right.
And so
there has been some hypocrisy on the Lively side. I will say that just that you're trying to look at objectively, it does seem like they have really played with their, they've been punching with the gloves off. They're really fighting hard and maybe even hitting below the belt from time to time, which you shouldn't do. But the same could be said for a few things that Brian Friedman has done. And there's also some things that Brian Friedman hasn't done. Like, he hasn't done things with things that you would think you would want to, like the Van Zam thing. Why hasn't Brian Friedman filed anything on Van Zandt? I know he's addressed it to the court, but there's been no filing on it.
You think there'd be some sort of a motion to exclude evidence that was obtained through that subpoena?
Correct.
And so, yeah, you wonder why that hasn't happened. And maybe it's coming and we haven't seen it yet. I don't know.
Well, I've seen some, I saw a person or two on the comments say, oh, he's got this master plan. I don't know how these people know this. They must be friends with him, or maybe they're at his firm, but he's got this master plan. And what he's doing is he's doing the rope-a-dope. He's going to make them think that they're real confident, and then he's going to hit them real hard. And you and I know that's just not how litigation works. If you have a strong argument to make, you're actually compelled to bring it, because if you sit on it, it's like a wasting asset, a decaying asset. The argument gets worse if you don't bring it as soon as you can.
Is it possible that he's keeping it until he does a motion for summary judgment, like a Rule 56 motion?
He could. I mean, he certainly could raise it there, but it seems to me that if there was evidence that was gained in this case, why not file a motion to have that evidence either excluded, have the other side destroy all that evidence and have to start over. And I know what he's, some people are going to say, again, you can put it in the comments, but you don't have to, because I already know, Brian Friedman's internal thoughts. He may be thinking, I'm going to save it for this particular time. That's generally not how, I don't know Brian Friedman, but I know litigators, and you and I know a lot of litigators. That's not generally how they think.
Yeah, normally you want to strike when the iron's hot, and that's a big issue. Yeah. And what a great way to get it in front of the court. And, you wouldn't have to worry about, the stupid argument that's come up that, oh, you're filing something just to get media attention. No, there's a real motion.
We're asking affirmative relief from the court.
Exactly. Yes. Yeah. So, it could be coming. It'd be great to see it if ever it is filed.
Yeah. So all this to say, Keith, just because there are people out there that are confused by this case. And by the way, I think people are confused by this case because it is a complex case.
Oh, yeah. Very complex.
But also there's a lot of people saying that this is important, and this is important, and this is important, and this is important. Okay, let's slow down here. There are some very important things in this case, but not everything is important. Not everything has to have all of our attention, and we don't have to be outraged by everything that Blake Lively's and her lawyers and her team do in this case. There are some things they've done that we can focus in on and say, hey, we need some explanation why you chose to do that. I think the Van Zandt thing is an interesting inquiry to find out, what did you guys know and when did you do it? Because if you pointed out, if they knew all this stuff, and everyone's going to tell us, yes, they knew all this stuff. I don't know how they knew. I don't know how people know that. But once that truly comes out in evidence, well, now you've got something that you can use against them.
Well, and that discovery is aimed towards finding that out. Friedman has to be busy doing discovery to find out, when were the text messages shared, who shared them, who knew what, when did they know it?
Right.
And, maybe that's part of why we haven't seen this motion yet. Maybe they're trying to do the discovery before they file the motion, which would make sense. It is a highly complex case. This is one of the most complex cases. There's so many different moving parts. And that's one issue. And then the other issue is there's a lot of unknowns. And so we're sitting here opining on different things. Maybe Friedman's doing this. Maybe, Lively side's doing that. We don't know. And, at some point, maybe we will know when it comes time for trial and you actually finally see the evidence. But you're taking complex issues and you're applying unknown facts. And we know some stuff, we don't know everything. So it's hard. You can't just sit here and say 100% it's this or 100% it's that, because, you got to juggle all these different issues and unknowns that we can't really speak to.
And I think it's okay if you really like Justin Baldoni. And I think it's okay if you really want him to win. I don't think it's okay if you just mindlessly go into an echo chamber and hear people scream and yell about how horrible Blake Lively is. I think you should be a critical thinker in life. I think you should I don't think you should trust anybody. Don't trust Ask Two Lawyers. Don't trust anybody. Look at it for yourself. Learn about it. You can hear it from all the different views. And then when you come to a conclusion, make sure you understand why. I remember Jim Cramer. He's this guy on MSNBC or CNBC.
That's a Mad Money guy?
He's the Mad Money guy.
Yeah.
And, he says people come up to him all the time. He encourages people to invest in stocks and so forth.
Oh, yeah.
And so people will come up and say, hey, I invested in NVIDIA. I'm in NVIDIA. I'm in Facebook. And I just love it. And he says he always asks people, I appreciate you telling me that, but can you tell me why you invested in those stocks? And just, deer in the headlights, right?
Right.
So my same thoughts here, and I don't want to, I'm not trying to be insulting to anybody out there, but ask yourself, why do you support Justin Baldoni? Why do you hate Blake Lively so much? And then write down the reasons, and then ask yourself, is that good critical thinking to formulate the opinion that I arrived at? Did I use good critical thinking to get there? And if you did, fantastic. But I just want to say there's nothing wrong with really liking Justin Baldoni. I like Justin Baldoni. I really like him a lot.
Yeah.
But I still think that I want to look at this case and use my own brain to determine, who is, doing things wrong here, who's doing things right. Are these just errors of omission? Are they just negligence, or is there a lot of intent behind what's happening here? And I think there's room for both of those analyses to take place.
Yeah, no, you make a good point. I mean, critical thinking is, and that's going back to the whole Charlie Munger thing, which is when you can articulate the opposing party's side, now you've strengthened your own argument.
Right.
And I think, it's not easy to do, but when you do it, it's well put. Yeah, I mean, this is just such a highly complicated case. It's a great case to learn on, though. If you really want to learn about the law and the ins and outs and just how tricky it is, and not only that, but every judge is a little different. I mean, I was thinking about this yesterday because a lot of times people have a hard time understanding. Like, I've talked to potential clients before, and they've told me, I can't imagine a judge ever ruling against me. And it's like, well, that's just, you don't have very much experience in front of judges then. I mean, think about it. How many judges do we have just in the state of California?
Oh, gosh.
A few hundred, right?
Yeah.
So just take 50 of them. Now, just in your own life, like your own neighborhood, go out and talk to 50 people and run some scenario by them. Doesn't matter what it is, just some factual scenario, and ask them, their opinion. And you're not going to get 50 of the same opinions, right? If it's any type of topic at all, you're going to get a variance of opinions. Now,
Sure.
You might get a majority of people saying one thing and a minority saying something else and some people in the middle, but you're never going to get the exact same response from 50 different people.
Right.
Well, judges are just people. And that's what I think a lot of non-lawyers don't understand is the law is a people business. So this is not engineering. This is not physics. These are not laws that are subject to the physical world. You can have an opinion on whether or not a beam is going to hold the load of the building above it, but the physical world is going to determine whether you're right or not. And if you're wrong, the building will collapse. And if you're right, the building will keep standing. But in the law, it's not like that. This is all a people business.
Mm-hmm.
And so the judge has their own life experiences, their own viewpoints they're bringing to the table, and so does the jury. And even bringing 12 people together and the 2 alternates, these are 14 different people that have a completely different background from each other, from you, from the lawyers, from the parties. And so that's what's so interesting, I think, about the law. And that's why the law is indefinite. It's very difficult to give an exact prediction about what's going to happen, because that would be like me giving a prediction about what any person out there is going to do in any given scenario. I don't know. Until it happens, we'll have to see.
Yeah, I'd be interested how many people called O.J. Simpson.
Yeah.
That one was that was a very, if you were a certain race, there was an opinion you would have on it versus another race. Then there was just strictly people that, saw it and said, I think that if you looked at white males and females, I think it was majority that he was guilty. Right. And obviously they were wrong. Now they might've been right in the sense that maybe he did do it. And I think there's a lot of people that to this day think he did it. But the jury determined that he did not do it. And I think that was a surprise to many people that had viewed the case because they thought this was just a slam dunk case. It wasn't, because like you said, the jurors are people, the judge are people, the lawyers are people. And you saw that was a messy trial and it ended with an acquittal. Everyone, is analogizing this case, the Lively versus Baldoni, to the Amber Heard and Johnny Depp trial.
Right.
Be careful because it's a different case. It's going to be a different judge. It's going to be a different jury. You might get the same outcome because there's a 50% chance you could get the same outcome, but it's going to be a different case.
Well, and keep in mind too, the jury only sees a narrow band of information. That's admissible evidence. That's all they're going to see. So anybody following this case, ourselves included, we could never be on the jury. We know too much. But we're looking at the whole universe of information, and you're making connections about things that have happened, things that Blake Lively has done. I mean, we've talked in the past about some of her interviews where she admits that she likes to come in and take over movies,
right,
or whatever. But the jury's not going to see all that. The jury has a very narrow band of information that gets allowed into the jury room. And that's what's another thing that's so important for people to understand. And so when somebody's saying, I can't imagine a jury ever siding for Lively, Well, you can't say that because you'll have to wait and see what admissible evidence the jury even gets to look at.
Right.
And then based on that, now we can kind of determine, do you think a jury would side this way or that way?
Although I do think that the judge here, this is just my opinion, I think he lets in that Forbes interview where she talked about taking over, from a creative standpoint. I think that does come in, but there's a chance it doesn't. I do think it does come in. But again, how many times have we been at trial, Keith? And I think Mike Alder, I don't know if he wants me to say his name, but one of the lawyers we know that were, act like you didn't hear that. There's a very, very fine lawyer out of Los Angeles, and he wins routinely $200-300 million a year in verdicts and settlements. He talks about trial, and he says the way you win a trial is heartbeat.
Yeah.
Heartbeat. He goes, because there are so many curveballs that happen at trial. And if you can keep your heartbeat slow and not panic, you'll be able to think. And when you can think, you at least have a chance to, and all of us have been in trial, and you've had this one piece of evidence for 3 years that you've spent a lot of time with, and you've developed written discovery around that piece of evidence. You've developed depositions around that evidence. Your trial is based on that evidence, and a motion in limine is brought by the other side to keep that evidence out because it's so damaging. And the court, and you're wondering, did the court even? How come the court's not seeing it my way? And the court's like, yeah, I don't think that evidence should come in. And you're like, Judge, this is going to kill my case. And the judge is like, it's not my issue. I'm just making a call whether the evidence comes in or not.
Yeah. So until we see what actually is admitted in front of the jury, we won't know. But it'll be interesting to see what that universe of information will end up being.
Right. All right, producer Eric, how are we doing?
Doing good. There's a lot of good questions here, I think. Not I think, I know they are. So, I mean, you talked about the strategy of withdrawing some of these claims, and there, maybe some stronger ones left, causes of action at the top. What are those, you think, for Lively? I'm wondering this as well.
Well, I don't, the notion that emotional distress underpins her whole case, I don't agree with that. So the intentional infliction and negligent infliction of emotional distress are just two claims, because there's other claims like the sexual harassment claims that don't necessarily depend upon emotional distress. So emotional distress is a term of art that we use in those types of claims. And the whole notion of emotional distress is it's something that is so outrageous that it shocks the conscience. That's what intentional and negligent emotional distress is. That's different from the damages that you can be awarded for something like sexual harassment or sexual assault or things like that. That's a physical thing. So, for example, if I punch Stuart in the face, there's a damage for that. You can sue for battery, and there'll be a damage for me punching him in the face. I'm liable. It's an intentional tort. Has nothing to do with whether or not he's emotionally distressed. And you put it in front of a jury, and the jury will decide, well, how much should Stuart get awarded for me punching him in the face? And then if the jury says, well, we think it's worth $500,000, then that's what it is. No emotional distress needed.
Although I would sue you for emotional distress too, because the emotional distress that I would suffer in that case is that you actually caused damage to me. I can't believe that.
Yeah, that'd be shocking.
It'd be shocking, yes.
Yeah, I'm surprisingly strong, but with really, those real fine muscles.
Yes.
Okay, next, Bridget Valentine wants to know, can Freeman bring in a therapist or maybe a psychiatrist at trial or ask questions related to emotional state during depositions? Would that be allowed, or how would that go over?
Bridget, good question. And I'm not clear on what you're asking. Are you saying like bring in an expert behind the scenes that helps him develop questions for asking a deposition? He absolutely can do that. Can he bring in a therapist at a deposition to ask questions? No. Can he bring a therapist to trial to testify? That'll be up to a judge. And at what I'm seeing right now, the two claims where you would bring that therapist in have just been withdrawn or shortly will be withdrawn. So the court's not going to waste time bringing a therapist in unless it's relevant. What are your thoughts?
Yeah, I agree. It's not likely that a therapist would come in as an expert, but it could. That could be the case. I don't know.
Right.
Maybe that was her strategy then, to withdraw those claims so she doesn't have to be subjected to something like that at trial. I don't know. That's just my thought, but
probably.
Amy, if the discovery window closes, what happens if new evidence is found?
You were talking about this before we came on, Keith. What do you think?
I mean, that's why you have to do proper discovery. So a couple of things. If you find some new evidence that was not accessible and there's no way for you to have found it during the discovery period that was allowed, then you might be able to still use it. But if that's evidence that was out there and you just didn't find it or you didn't do the work to issue the subpoenas to get it, then you probably would not be allowed to use it, because at some point you have to disclose all witnesses, facts, and documents that you're going to use. And if you didn't disclose something to the other side, then you can't use it come time of trial. Now, there are some exceptions, and the judge can always, vary that if needed. But by and large, that's what the discovery period is for: is go out, find all the evidence that you're going to find, make sure both sides get full disclosure of all the evidence, and then the discovery period closes, and that's the evidence we're going to use. The whole idea of discovery is to allow each side a fair opportunity to have equal access to all the information.
Right.
Because before discovery, you would have these, Perry Mason moments where one side knew something, the other side didn't. And it was meant to eliminate all that. So that's kind of the purpose of it. I don't know. Do you agree with that?
Yeah, there's no more Perry Mason moments for the most part. And once the discovery window closes, there is a chance to open discovery, but you have to have a really good reason. You have to explain to the judge that it was not lack of effort on your part, during the discovery window, and there's some new evidence that's come to light and we want it. And so for example, I've seen judges right in the middle of trial. It doesn't happen often, but there's a new witness that comes in and one of the parties tries to introduce that witness, and that witness was not disclosed in the discovery window. And the judge, rather than excluding it, says, I'm going to take a day, we're going to do a dark day at trial, and you guys are going to go take that person's deposition tomorrow, and then you're going to come back and you're going to report to me what you found out. I mean, that does happen from time to time. I don't get that Judge Liman is that kind of judge, but it could potentially happen.
Yeah.
Okay, thank you. Let's go to. Well, first, Becky Friedman says that no case is a slam dunk, and yeah, why would you think like that? You were relying on jurors that you do not know.
So, can I make a comment to Becky? That is one of the most astute comments I've seen today. Maybe in a while. And the reason is Keith, you and I both have people, good intentioned people, that come and visit us about taking a case on.
I got a slam dunk case.
I've got a slam dunk for you. And
right.
Your response to that is, look, I appreciate you sharing that, but generally speaking, we've been doing this, for 20 years each, so 40 years collectively. How many times have we had a slam dunk?
Never.
I can't think of one where it was just a slam. Now, there's cases that have better facts.
Yeah, you have strong cases and you have weak cases.
Some cases better law.
Yeah.
I mean, that does happen, but a slam dunk, I just haven't seen it.
That's because it's a people business. Like she pointed out, you don't know these jurors.
Right. And to that point, JT says, how likely is it that the jury members will not do a quick Google search, even if they're instructed not to? This is a question.
Can I answer this one?
Yes, please.
Can I answer this one? So there's jury instructions, and the judge spends a lot of time going over these jury instructions, and the judge will spend a significant amount of time on this particular jury instruction, because I hate to say it, but it appears that jurors ignore this. They don't ignore it, but they just can't help themselves.
It'd be too tempting.
Yeah. So they go home. They're not supposed to talk about it with their family or friends. So you can sequester the jury, right? But then they've got their phones. You can't take their cell phones away. I mean, that's just horrible. That'd be horrible for a juror to have, be basically sitting in a room without a cell phone for, days on end during a jury trial.
Right.
So look, I'm not saying that all jurors do this. I'm sure there are some jurors that follow the instruction, but boy, it's tough. It's really tough not to look on Google and do a quick search on what's been happening in the trial that day and finding out all the things that you weren't allowed to know about. But jurors are not supposed to do it, and we hope they don't do it.
Right.
Because judges are there to preclude them from hearing things for a reason, because the judge doesn't think that it's appropriate for them to hear because it'll be unduly prejudicial or whatever the case might be.
That raises a good point. Like, why do we have the evidence code and admissible evidence? Why can't they just go out and do Google searches? And what's the whole point of that?
Well, because we want to make sure that we have the best evidence, and we want to make sure that everything is relevant and that the foundation is set, and that it's not based on, my brother's cousin's aunt's husband who saw something. And this is the fallacy of revenge movies. The fallacy of a good revenge movie is that the Punisher, he always kills the bad guy. In reality, what if he kills the wrong guy? because the evidence just isn't that good. And so we want to make sure the evidence is credible. We want to make sure that there's a reason to listen to it.
And authentication, right?
And we want to make sure it's authentic and genuine and all those good things. If you don't do that, then you let some bad evidence in. And by the way, judges are people, so there's sometimes bad evidence that's let in. Sometimes good evidence is left out. But for the most part, they're to be an umpire, and the judge is doing their very level best to make sure that there's a fair trial for both sides.
And both sides have to live by the same rules. So both sides have to authenticate their evidence, and that, in theory, makes it an even and fair playing field as it's going to the jury.
Yeah, and getting evidence introduced at the time of trial is not easy. A lot of people say that evidence is so overwhelming here. It may be in the court of public opinion, but getting that into the court, because there's certain, like there's speed bumps you have to get over in order to get evidence in front of the court. And you've got professional lawyers on the other side that know the evidence code backwards and forwards.
They're fighting you.
And they're telling you, you can't have this in, judge. And so then the judge has to make a decision. And the judge isn't going to deny them on everything they're asking you to keep out of the case or to put into evidence. The judge is going to give them some of the evidence they want. It's going to give you some of the evidence you want.
Yeah, exactly. Yeah.
Okay. Does the jury have to be unanimous for a verdict, or is it most at a trial like this?
Well, this is a civil case, Stuart. So what do we need in a civil case with a jury?
So if California a law applies, well, first of all, federal court's a little bit different. Federal court, you do need unanimity. Thank you.
Welcome.
In California, you would need 9 of 12. And you just do that ratio on, if you have 8 jurors, you use the same ratio. But I believe with the federal courts, if I'm not mistaken, and somebody can let me know, the jury pool can let me know, I think you need 100% of the jury in a civil case as well.
Yeah.
I could be wrong on that.
Okay, thank you.
Good question.
Yeah, I was curious as well. Amy, that was from Bridget. Thank you. Amy Kemp, do we get to hear all the info in depositions, we as in the public? I'm guessing no, but...
I don't think so.
Can stuff get leaked? Is it possible?
Well, you can watch depositions now from like 5, 6, 7 years ago in cases, so it does somehow make its way on YouTube. But yeah, you're not gonna. This is not. I think what will happen is there will be leaks to the press about a particular piece of evidence or a certain way somebody testified. I think that'll happen. The judge doesn't want it.
Or you might see clips of the deposition at trial.
Yes.
Because sometimes that's used for impeachment purposes, or with the parties, you can use it for any purpose you want.
Right. Yeah. Just a quick tip. If your deposition's ever taken and then you go to trial 6 months to a year later, sometimes a year and a half later, it's super important for you to read your deposition the night before you testify. And you'll be amazed at how much your memory moves and changes over that time period. And the last thing you want is a lawyer asking you a question and you say no to it, and then you hear the words, "Do you remember having your deposition taken, a year and a half ago?" And you said yes rather than no. So what we do with our clients is we require, when we go to trial, that they read the deposition transcript a couple times before they testify, because we believe they testified truthfully at their deposition. We just don't want that. The brain moves, the brain meanders, the brain changes stories over time. Not that you're lying. There's actually a jury instruction on this where 2 people can see the same event and see 2 different things happen. And I know jurors are like, "What? How come Keith saw it this way and Stuart saw it that way?" Keith and Stuart aren't lying. That's just how the brain works.
Yeah, you just don't want to be inconsistent. That's really important.
Thank you for that. I like this one. When ruling on a specific motion such as this, to what extent does a federal judge consider the big picture, such as all the other cases involved?
Wow, that's an interesting question.
I mean, I don't think the district courts get caught up in that too much. I could be wrong. I've never been a judge, but it seems to the appellate courts and the Supreme Courts, they definitely look at things from a policy standpoint, right?
I think so. Yeah, maybe the federal district judges look at that a little bit more. I think the state courts, the judges there, they just have so many cases, especially in California, they just are handling so many cases that I think they just rule per case. I'm not sure that they're particularly interested in how it affects other cases. I remember you and I were in court, this is years ago, and the judge made a ruling on one case, and then the next case was called, and we were watching, and
Oh, that was embarrassing.
right, one of the lawyers said, "Well, Your Honor, you just ruled this way, and the case that you just heard before us, and my case is the same way, so you have should rule for me." And the judge did not like that. Just shut that down.
The judge took that lawyer to task. And the saddest part about that was that's a lawyer we know and we like, and he's a good man.
Yeah.
And he got embarrassed badly that day. Yeah, because you're not allowed, just so the jury pool knows, you're not allowed to point to precedent at the trial court level. You can only look at appellate courts or Supreme Court opinions, and even then they have to be published in California. So yeah, he made a mistake that day, and my guess is he didn't make that mistake again.
But I will say that, it could be like the ruling even that the judge did today, where he told both sides, you're denied and figure it out. But just so you know, I'm not going to allow evidence. That could be the type of ruling that Judge Liman wouldn't mind if other cases saw and just, paid attention to the way he does things.
Work it out, lawyers.
Yeah.
But by the way, that's another reason that you don't want to always be throwing bombs at each other. Because if you're constantly throwing bombs at each other on outlandish accusations, you miss the opportunities to actually work with opposing counsel. And so I like what Judge Lyman's doing here. And I don't know, I'm not in his head, but I'm going to guess he wants these lawyers to start to work together. They're going to have to work together. They're going to have to do joint statements for the case. They're going to have to put an evidence list together. They're going to have to put a witness list together. And they're going to have to talk about how much time each person gets. You need these people working together. And it's very hard because we're in an adversarial system, Keith. And if I'm going against you in a very heated case, I don't like you.
Right.
I want to destroy you. And yet I have to sit down and work with you.
Yeah.
But then when I sit down and work with you, I go, oh, hopefully, he's a human. I'm a human.
We can work it out.
We can work together. Yeah.
I want to get to this super one. New York Times just added a new lawyer to the docket, Amanda Levine. Does this mean there's a lack of confidence in their motion to dismiss?
That's interesting. I wouldn't think so. I mean, I think that they're probably very confident in their motion to dismiss. I'm not sure why they would have added another lawyer unless they were thinking in the event that they don't win their motion, maybe they're thinking they need litigation counsel. It could be that the lawyer that drafted the motion to dismiss was it was a very well done motion. It's almost like it was an appellate attorney. So I wonder if that was her specialty, and now they want to add somebody just in case they don't win to be a litigation specialist. I don't know.
Yeah, we'd be just guessing at this point, but I will say that the lawyer, and I forget her name, Eric, the lawyer that drafted the 12b6 for the New York Times, one of the best writers I've read in a long time.
I can't remember that name off the top of my head.
She probably is their appellate person because it was very well done.
Okay. What did you favorite some of these ones here?
I did.
Oh, okay. Would you say Baldoni has a stronger case?
What do you think, Stuart?
Mildy, contrary to what I read in the comments, yes, I do think he has the stronger case. And I think if they can stay focused on the evidence that we've seen thus far, and there's not evidence that surprises us based on Blake Lively's side, I think that there's a very good chance, greater than 60%, 70%, that he could win this case at the time of a jury trial. But keep in mind everything I've said thus far. You never know how these cases go. You never know how witnesses ultimately do testify. You don't know about the evidence we're going to find. But from what I've seen thus far, I think that Baldoni has the better case. And I also do think he's more likable. And I know some people have said they don't like the fact that I point that out. Look, being likable is not a bad thing.
It matters in front of a jury. It does.
Yeah, it's a good thing. And Amber Heard clearly was not likable. And Johnny Depp, who's not more likable than Johnny Depp? I mean, everybody likes Johnny Depp.
Yeah, and that's not to speak to his claims. You're just saying that this is a person who's going to present well in front of a jury. And anytime we're at a mediation with a retired judge, one of the things that they try to gauge is
the demeanor of our client.
Are they going to be a good witness in front of a judge or a jury? And that's very important.
Yeah. Oh, Bridget Valentine doesn't like Depp. Okay, Bridget, you, and then there's 7,900,000,000 other people in the world like Johnny Depp. No, Bridget, you're that's well taken. There's people that don't like him, but I do think he's a likable person,
or at least he made a good witness in front of the jury.
Yeah.
What's an acceptable settlement in your view now? It's tough to say, but.
Well, I think any good settlement has to start with both sides giving a few $1 million to ask two lawyers in the jury pool because we've been through a lot.
Grishma, it's a pretty name. Grishma Girish, thank you for your question. What do you think? What if
An
you,
acceptable settlement.
an acceptable settlement right now today? If we were settling this case today,
Boy, that's a tough one. I mean, because from Baldoni's side, you're thinking, I want a career. I want a career when all this is over and I've been damaged. And so how do you compensate for that? Money's not enough. Now, there's going to have to be some monetary payment, you would think. But then on the Lively and Ryan Reynolds side, they're thinking, why should we pay you a dime? You were a terrible person. I think ultimately there would have, based on what we know now and based on the evidence that we have now, I think for this to settle, there would have to be some payment of money from the Lively side to the Baldoni side. And I would also think there'd have to be some sort of public statement made, and maybe it's by both sides, but at least by the Lively side, in order to hopefully help Baldoni, get past all of this. And maybe the statement's something more generic, like this was a big misunderstanding, and there was facts that happened that were misinterpreted. I don't know, something like that. But there'd have to be something done, I think, along those lines. What do you think?
Yeah, I think there's if there's a payment of money, it's going to, in my mind, coming from the Baldoni or coming from the Blake Lively camp to the Baldoni camp. I don't know how much. I mean, this has gotten really expensive and it's gotten very cluttered, and there's a lot of issues now. I do think Baldoni had a better case 2 months ago, 3 months ago, and that would have been the time to try. And maybe they did. We don't know. They could have tried to settle at that point. But now it's getting messy, and it's going to continue to get messy all the way to trial. But yeah, there'll be a payment of money. I don't know about a public statement or not. If there was, it would be very neutral. I agree with that. More than likely, there'll be a confidentiality agreement, and it's to preclude any of us from knowing what happened because of the egos that are involved on both sides. And when I say egos, I'm talking about just the normal egos. I don't think these are super. I mean, there are people with big egos here, but the point is that none of us, if we were famous, would want the world to know what the settlement was, because then people are going to make judgments on why we entered that settlement.
And things like public statements or apologies almost never happen in settlements. And, we've had clients who say, part of the settlement, I want this amount of money and an apology. It's like, You're not going to get the apology.
Right.
You're going to get the money. The money is the apology.
True. That's well said. Can we talk about Rule 11? And maybe we can wrap after this one, but is it sanctionable or at least frowned upon to bring that before rulings on the motions to dismiss?
You had a comment on this earlier today as well, Keith.
I did.
It seems like you've been talking to the jury pool without notifying me.
Yeah, I've been whispering. There actually was a response filed, and we didn't go into it today, but there was a response filed to the Rule 11 motion. And the thing that was interesting that Brian Friedman pointed out is that a Rule 11, which is for sanctions, that's where you say that somebody filed something when they had no reasonable basis in fact or law to do it, and it's sanctionable. But they pointed to case law that said that you're not supposed to use a Rule 11 motion when you're just replicating your arguments in your 12b6 motion to dismiss. That's not what it's there for.
Right.
And so I always thought that Rule 11 motion was kind of nonsense when they filed it, because it's like, well, you made allegations, you had a reasonable basis to make these allegations. What's the big deal? And so that's kind of what the response was, which is, look, we made allegations. They have an avenue to attack them with their 12b6, which they did. This is not a Rule 11 issue. Mm-hmm. So I think it is premature to file it now, and I don't think they're going to get anywhere with it. But, it's litigation, so both sides want to keep the other side working on whatever it is.
Yep.
One more. Sorry, I lied. Will the Van Sham lawsuit bring criminal charges?
I mean, the Van Sham lawsuit, in the sense that the lawyers, I think it was Miss Katz from
Manette
Phelps. Yeah, Phelps had filed this in New York State Court. I can't imagine any criminal charges being made against her. The issue for me there comes down to the procedural rules that are allowed in New York, and as I understand it, there is a pre-litigation route she could have taken, which requires a judge to sign off on everything. And I think there's notice then given to everybody, or the judge can make sure that happens. That's not what they chose to do in this case. They took the much more aggressive position, and that was that they were going to file the lawsuit. The question still remains, why? Why did they do that? Did they do that because they knew everything? Did they already have all the text messages? Did they already know what they were going for? Or were they told, hey, we've got some stuff you want over here, but we're not going to go into it. So, but if I got a subpoena, I'd give it to you, which, I've always felt that Stephanie Jones, and I think I got her name right today. I've always felt that there's an issue there. In fact, she just recently sent a cease and desist letter to somebody. But she had a duty in my mind, and I don't know if she complied with this duty. It doesn't appear she did, but she had a duty in my mind that once she received that subpoena, because of the relationship she had with Justin Baldoni and Wayfair, she had a duty to notify them and even provide the subpoena to them and say, hey, you guys do what you, I'm going to give the documents unless you guys do something with this. And certainly any lawyer worth their weight would have taken one look at that subpoena and dashed off and filed a motion to quash or objected, whatever the rules require for you to keep that subpoena from being complied with. And so I do think that there needs to be some more attention put on what happened there.
Yeah, because Stephanie Jones is the one that had a contractual confidentiality with Wayfair.
Right.
So really, she's the one who had the duty more than anyone to protect that information and keep it confidential.
Correct.
She gets a subpoena. She doesn't even tell them, allegedly. That's what we've been led to believe by the pleadings. If that's true, I don't know if she was talking to a lawyer when that subpoena came in, but I would hope that the lawyer would have said, hey, you should show this to Wayfair. You've got a contractual obligation. I don't think there's going to be any criminal charges because of the Van Zandt, but that doesn't mean that Judge Liman couldn't take action if a motion is filed by Friedman eventually.
Right.
Not criminally, but take actions to kind of do things in the case.
Right.
Cool. Thank you, guys.
Do you have anything else there, Eric? I thought I had one more. I like this comment here from, I guess it was S. I love this take. Very, very measured and thought provoking. I'm now a fan. Well, thank you, S.
Yeah. Thank you very much.
Yeah. There's a lot of nice commenters, and we're glad everyone's could join us today. We're at about 2,300 people. So, wow. I feel like we never expected we would get views like this, but we're thankful for everyone.
So I want to end this by challenging all of us, including us and Eric, and everybody that's listening. Doesn't matter who you are, what your educational background is, where you come from, your view of the case. It's okay for you to have a side. It's okay for you to push for that side, but think critically on the case. Think about the people that are telling you stuff about this case and ask yourself, maybe I should analyze this a little bit closer. And that counts for everybody. It's not just, a person out there that's not a lawyer. All of us could stand to sharpen our critical thinking skills. In fact, we do it every single day here in this office. It's a humbling experience at times,
I'll say,
but it's worth it because it forces you to ask yourself why it is you believe what you believe. And then you feel better about it at the end of the day. Oh, I know now why I believe in this argument, and I have a basis to back this argument up.
And you can articulate it when, what's his name? Kramer?
Jim Kramer.
What's the
Jim Kramer?
Yeah.
Yes.
So then you can articulate your reason when you bump into Jim Kramer and he asks you why.
Yeah.
So yeah, that's good.
Yeah.
I like it.
So, all right. Well, we'll see you guys next time. Thanks so much for joining us.
Have a great afternoon.
We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.